Welcome to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Jackson, Mississippi. His motto is, more for you and less for us.
Joey, what happens when we go to court for a DUI?
Generally, there are two court appearances. The first one is your initial appearance, and that's where you show up, and the prosecutor may or may not offer a plea deal at the time. And what you do is you plead guilty or not guilty, and that's it. There's no trial. There's no evidence put on. You walk in, the judge will ask you, how do you plead? Either guilty or not guilty. That's all they want to know. The second date is likely your trial date. And at that point, the prosecutor and your attorney should have spoken. Discovery should have been exchanged. And any plea deals that are on the table, that's when you will accept a plea deal generally. Otherwise, you go to trial, and you'll be looking for the officer that arrested you to actually appear because you have a right to confront your accused. And you will have a trial. The officer will get up and testify. That is usually the only person that will appear. If you have another substance DUI and some other substance is found in your vehicle, or you have an open container DUI or open container that goes along with your DUI, then they will need to have somebody from the crime lab there with the reports showing that it is actually a controlled substance or it is alcohol above the legal limit.
What kind of preparations do you have to do?
You need to review the police report and any kind of videos with your attorney that may exist of the incident whatsoever. You need to review any notes that you may have made. You need to sit down and discuss with your attorney your options, whether or not you want to testify, and you need to go over the witnesses and what we can expect from them in detail with your attorney.
Will my case be decided by a judge or a jury?
It depends. For a DUI first offense or second offense, it will be a judge-only trial, no matter what level you are at. If you're at the municipal court or the justice court level, you will have a judge. If you have appealed or pled no contest and gone up to the county court, then you will also only have a judge. However, if it is an aggravated DUI, a third offense DUI, or a fourth or subsequent offense DUI, you will have a jury because those are felony charges that carry over a year in jail. And the United States Supreme Court has said that entitles you to a jury trial.
With any of those options, will I have to testify?
You are not required to testify. You absolutely have the right to remain silent. I almost always advise my clients not to testify. There's generally nothing they can say that I can't disprove from the other side already based on the evidence in front of us. And you have to keep in mind that these prosecutors, they might do 4, 5, 10 trials a week. This is what they do all day, every day. Most people don't get a DUI once in a lifetime, twice if they're unlucky. So I always advise them not to, because the prosecutor is experienced in asking the questions. And to be frank, the individual charged is nervous that they're going to lose their license or something more serious is going to happen. And they're not 100% in it. Present sometimes. On top of that, they just don't have the experience on how to answer those questions in a manner that they don't get tangled up. So I almost always advise my clients not to testify. But you absolutely have the right to testify if you so desire against the advice of counsel.
Thanks for listening to Ask a Lawyer with attorney Joey Franks at the Franks Law Firm in Jackson, Mississippi. Call attorney Franks at 601-773-7777. His motto is, more for you and less for us.